Welcome to Ask a Lawyer with the attorneys at the law offices of Karen and Ulmer, PC. Each week, we answer your questions about the law and how it affects you. Today, it's noted family law, estate administration, and real estate law attorney, Michael Raisman.
When is probate necessary?
Probate is necessary whenever assets are in the decedent's name alone. For example, if the decedent passed away with a bank account in his or her own name, then you need to open probate. And whenever accounts are in joint names or with the beneficiary, then the accounts go to the survivor. For example, a 401k or life insurance policy usually has a beneficiary on it. They usually bypass probate. Similarly, if a bank account's in joint names between a husband and wife or parent and child, probate is not necessary in those cases. However, if there's an account in someone's sole name, a vehicle, a house, bank account, then you do need to go through probate.
Okay, Michael, so who files for probate?
Probate is done by either the executor or administrator. An executor would be the person named in the decedent's will. An administrator is when there is no will. Usually it's going to be the spouse or next of kin, child, for example.
So how do you file for probate?
So to file for probate, you go to the courthouse where the decedent lived at the time of his or her passing. You will bring with you a checkbook, the original will, if there is one, a death certificate, and your photo ID. That's the photo ID of either the executor or the potential administrator. And you can file a petition for a grant of letters.
So what are the steps involved in the probate process?
Well, once you go down to the courthouse and you file a petition for grant of letters, then you will be the administrator or the executor, depending on whether or not there is a will. Once you are determined to be the administrator or executor, then some of your responsibilities include notifying heirs, advertising in 2 newspapers, including the local county's law reporter. You need to file the inheritance tax. The inheritance tax is due within 9 months of the decedent's passing. However, if you file within 3 months of passing, then you get a 5% discount on whatever is owed. If the decedent was over 55 years old, then you have to contact the Department of Human Services for potential medical assistance recovery. Once you're the executor and you've done all the steps in the first process, then the next series of steps include determining the assets and the liabilities of the estate. So in other words, what real estate existed, bank accounts, stock accounts, what liabilities, including credit card debts, personal debts, mortgages, or any other liabilities. You need to pay the debt to the estate. You would sell or transfer real estate and any other assets. And then finally, you would distribute funds either through court or hopefully by agreement of the parties, including the beneficiaries and other family members.
So how long does all this take?
Generally, it takes a little over 1 year. Once you advertise in 2 newspapers, then the creditors have 1 year from the date of advertising in order to make a claim against the estate. If you distribute prior to the 1 year and a creditor comes out, then the executor or administrator is on the hook for any liabilities not yet paid. However, if you wait more than 1 year and no creditors have come forward, then you can distribute all the assets without an issue.
Thanks for listening to Ask a Lawyer with Michael Raisman at the law offices of Karen and Ulmer, PC. Join us next time as we answer your questions about the law and how it affects you.